Thank you. Please be seated. We are here this afternoon for the submission of 4 cases. State of Iowa versus Murphy Rutherford is hereby submitted without oral argument. State versus Dalton Cook is hereby submitted without oral argument. And State versus Brown is also submitted at this time without oral argument. So we are now going to proceed with our oral argument. State versus Geddes. And it looks like the parties are ready. Ms. Stewart, you may begin.
May it please the court, counsel. I am Ashley Stewart and I represent Robert Geddes. The government violated Mr. Geddes' First Amendment right to free speech when it convicted him of trespass as a hate crime based on the content of his notes and his viewpoints. Mr. Geddes' content and the words in his notes did not fall under any restrictions under the First Amendment, including pornography, defamation, obscenities. So the only thing it could have possibly fallen under that the state is relying on is fighting words. Fighting words are words that by their very utterance inflict injury or tend to incite immediate breach of the peace. Mr. Geddes' notes did none of those things. In fact, he simply told homeowners to burn flags. He didn't encourage them to burn them, he didn't tell them he would burn them himself. He didn't say he would return to their homes and inflict violence if they didn't burn the flags. He was merely sharing his viewpoint. He didn't want to confrontate.
As arguing that those were true threats as opposed to fighting words. Is there a difference?
There is a slight difference. However, in this case, again, true threats have to be something that is going to cause immediate concern of violence.
Would follow the direction of that note and start that flag on fire, which is connected to a home.
Right. So I think the difference here between that statement and what happened is that no one actually burned the flags. No one was actually told that if the homeowners didn't burn the flag, someone else would burn it. And so
that's burn the flag to me reeks of fire, an object that's attached to my house.
Add more to the note to get to that assumption. The note is just a statement. It doesn't suggest any action on the part of Mr. Geddes or anyone else. It's just a sharing of his opinion about a flag needing to be burned, but there's no action statement there. And then
English class, you can make a statement, burn that flag. I mean, that is action, isn't it?
I think it can be if it says, I will burn that flag, or you should burn that flag. Just saying burn that flag, to me, doesn't indicate that an action is actually going to happen. And on top of that, if you look at it, when Mr. Geddes delivered these notes, he didn't knock on any doors. No one was home. He didn't have any face-to-face confrontation. It was literally just a note left on the door.
Ms. Stewart, I tend to agree with you and disagree with the state. I agree with you that it's not a true threat or it's not unprotected speech. The problem is, really, technically, that's not what he was convicted of. He was convicted of trespassing because he entered on property that wasn't his, and then he went up to these doors and he posted notes to the doors, I guess, next to the pride flags, and that's a trespass. And then that trespass was enhanced because of his intent, not because literally of what his words said. And the Supreme Court said that's okay too. You can have hate crimes where you punish people as long as their fundamental conduct is not protected. You can punish them more because of their intent. Isn't that what's going on here?
I believe the trespass was triggered when Mr. Geddes, or could have been triggered when Mr. Geddes walked the door and left an inanimate object, which is the note. But to get to trespass as a hate crime, the state had to take in the contents of the note in order to get to hate crime. And so without the contents of the note, it isn't a hate crime, according to the state. And so essentially it's a circular argument, but it means in order to get to the hate crime, you have to punish the contents of the note. The only way you can do that is if it falls outside of the restrictions, outside of what's protected by the First Amendment.
Another example, just to play this out. Let's suppose someone was wearing a T-shirt and on it was protected speech, but it's definitely aimed at a particular, let's say, racial group, and they go up and they're caught on camera burning a church. Couldn't, even though it's protected speech on the T-shirt, couldn't that be used to give us a window into their intent in burning the church, that it was perhaps a hate crime?
I think if it could, maybe, possibly. I think the difference here is that the hate crime is only being punished because of the contents. So in your example, he has on the shirt, but then he burns the cross. He does something more. He burns the church. He does something more. In this case, that didn't happen. There was no violence, nothing connected to it. It was just a note. There was no extra step.
Maybe a selective prosecution issue versus the actual hate crime issue, right? I mean, granted, if he had left, if he worked for a restaurant and left a flyer on the door, they probably wouldn't have prosecuted him. If it was a city council race and somebody put a political advertisement, they wouldn't have prosecuted him. So the criminal act is leaving the thing on the door. What motivated the prosecution seems to me to be a different question, right? What's your response to that?
The same, even with selective prosecution, it was selective because of the words that he used, which now means it infringes on First Amendment protected rights. And so because his rights were protected, he shouldn't have been prosecuted for trespass as a hate crime.
It seems to me that the underlying trespass statute is perhaps unconstitutional of just leaving any inanimate object. We've got the U.S. Supreme Court Watchtower case. We've got older Iowa precedent that struck down ordinances prohibiting canvassers from doing that. Are you challenging the any overbreadth of the trespass statute?
Doing it under vagueness and overbreadth. Directly to your point, if anyone was to knock on the door and leave a flyer, as Justice Mansfield referred to, and Justice May, I believe, leave a flyer about a pizza parlor that's opening up down the street from the house, from the homeowner's house, that person would not have been prosecuted for trespass as a hate crime. And in general, in American society, we think that going up to the door and leaving a note is fine behavior. It's not a criminal prosecution.
You're brief, but I'm just curious what supports that people generally would think it's okay to walk up to someone's house when there's a statute on the books that says walking onto someone else's property without their express consent and leaving an inanimate object. That's it's broad, but it's still pretty specific about what it is that you can't do.
Because in everyday life, we've all gotten flyers left at our doors that we didn't give permission for a flyer to be left there for various reasons, for innocuous reasons. But on top of that, in Harding's, it said, we expect Girl Scouts to come to our front door and knock on the door and sell cookies. All of those things.
To Justice McDonald's point of, that sounds like selective prosecution. It might be that the Girl Scout who leaves the flyer in your door when you're not there isn't prosecuted, but she still probably violated the statute. No one's suggesting that she didn't violate the statute. It's just whether or not she would actually be prosecuted.
The heart of part of the vagueness argument, when there's arbitrary enforcement, when a police officer can decide who and what to enforce based on the content of the note. So,
I mean, this might be kind of hyper-technical, but I mean, what like the Watchtower case and says is protected is going up to the door and knocking and soliciting unless there's a no solicitation sign. But even if you take out the content of the message, what Mr. Geddes went beyond that, he left something, and he didn't just leave it like on the ground. As I understand it, he actually, taped it to the doors of these places. So, in effect, using these homes, or in one case a business, as his own like bulletin board, right?
can be equivalent to you getting a flyer for that pizza parlor again and it being stuck or wedged inside your door. It's left there to stay. It's used as a bulletin board, but that person is not being prosecuted because the contents of the note are generally accepted because you're being invited to try a new business. The same thing with Mr. Geddes, but the only reason he was prosecuted is because the state didn't approve the contents of his note. And so also I do want to take some time to touch on trespass as a hate crime in general and the way the elements are presented. We, of course, are arguing that the district court misread the elements, that the elements as written in the statute should be 2 intents and 2 acts. So first should be the intent to trespass and then the act of trespassing. And second should be a hate crime intent or a hate crime act. And when you put those together, then Mr. Geddes didn't even meet the trespass as a hate crime because he didn't have 2 intents with 2 acts. And so in order for him to have been convicted of the hate crime, for example, he needed to have trespassed on the property or had the intent to trespass on the property and then committed another hate crime. So an assault, an arson, criminal mischief, or a secondary trespass, as it should be interpreted by the statute. And so that's why we're arguing, of course, that it was insufficient evidence to convict him of trespass as a hate crime as a whole.
Additional authority cited the Counterman case. How does that help you?
Case, which recently came down, of course, says that the state has to prove that the defendant knew that there was a substantial risk that the party receiving, in this case, the notes, would believe that there was imminent harm or were they at risk of harm. I think it helps Mr. Geddes here because, number one, there was no evidence introduced of what his intent was and what his state was and what he thought. So we don't know if he was thinking that the people receiving the note would think they were at substantial risk of harm, just like Mr. Counterman. So even if you decide they're fighting words, they can still have an exception. He can still not be convicted under Counterman because he didn't have the knowledge, or excuse me, he didn't have the reckless mental state.
With your reading of the statute about having 2 intents. So if we conclude the statute is simply entry and leaving an inanimate object is a trespass, then is Counterman relevant here?
Relevant because Mr. Geddes was still convicted of what he said in the note. So then you would still have to do that analysis because he was not just convicted of trespass. He was convicted of trespass as a hate crime. So now you have to find out where the hate crime part comes in. And the state is saying the hate crime is the contents of the note. So now you have to go into an analysis of were they fighting words? If they aren't, you're done. If they are fighting words, then you have to go to the Counterman analysis.
This is technical, and I think a lot of these speech cases are. He's not being prosecuted for the content of the note. If the notes were all blank and the police approached him and said, well, why did you leave these blank Post-it notes on these doors? And he said, because I was motivated by my hatred for gays, then that would still be sufficient to satisfy the statute as I read it, even if there was no content on the note, right?
I believe that the only reason it rose to the hate crime bar is because what was said in the notes. And so otherwise, there's no impetus to say that it was a hate crime. There's nothing there except for leaving a note on a door. But because it said burn that gay flag, that's what took it into hate crime.
Upon being questioned, I left these blank Post-it notes there because I was motivated for these prohibited reasons.
Government can police what someone is thinking either way. And so in this case, they were policing what his thoughts were because the thoughts were written out. That's the only way they knew that, or they decided that it was a hate crime.
The government, there are laws that police these kinds of things. So there are employment discrimination laws, right? I mean, you're allowed to fire people, but you can't fire people for particular reasons, right? And the same thing with this. You can't leave a note on the door, and you can't leave a note on a door that's punishable for a particular reason that triggers an enhanced punishment. So I guess I don't see why those are different.
I think you still have to go back to why did it rise to the level of a hate crime? And it's because of what was written on the notes. Without what was written on the notes, there's no hate crime here. And so in order for the state to prosecute Mr. Geddes for a hate crime, they have to be putting punishment on the words that he conveyed. And the words that he conveyed were protected by the First Amendment, so he could not be punished for them.
If he put that note on everybody's house,
No.
and he put it on the homes of 5 people who happened to have the gay flag there, correct?
I will say we don't, and I said this in the brief as well, we don't even know what was behind the gay flags. People could have just put them there because they were nice flags. We don't know what Mr. Geddes' intent was. We don't know if he wanted to incite violence. Actually, what we do know is the words he put didn't lean to inciting violence. They were just statements. Maybe he was just trying to convince his neighbors. We don't know. And because of those reasons, then his speech should be protected under the First Amendment and also under Counterman. I see I have 23 seconds. I'll wrap up here unless there are any additional questions.
The other round. Thank you. Mr. Rogers. Where's your sweater?
How's the Achilles heel doing?
I get both. I should say, may it please the court, it's a beautiful day in the neighborhood. Content of speech is important to this case. And flying the pride flag is sending a message. We see you, we're with you, LGBTQ plus community. And that's...
Stop you there. This statute, 729A2, says hate crime means one of the following public offenses when committed against a person or a person's property because of the person's race, color, religion, etc., which we don't have here, so we move to the second part, or the person's association with a person of a certain race, color, religion, etc. Who is the person that they are associated with, that these homeowners are associated with, that gives rise to a claim under 729A2?
I would say that person includes people, and the association is with people involved in the common, the collective effort toward social, political, or cultural goals that are part of the LGBTQ plus movement, if you will. But the banding together of that group.
It doesn't say a person's association with a movement. It says a person of a certain race, color, and in fact, it says political affiliation later. So it seems to me when the statute wants to talk about association with some affiliation or with some movement, it says so. But here it's not like the posting was made because I know that person X lives there, a person of a certain religion or color or whatever. Here we have a symbol, which is a pride flag, but I'm having trouble connecting it to a person that this statute refers to, because I think reading it your way, we don't need a person of in this sentence.
I can't think of a movement that isn't comprised of people and persons.
It more complicated? I mean, is it a reasonable inference that somebody who puts up a pride flag is demonstrating their association with persons of a certain sexual orientation?
I'll adopt that, yeah.
Which sexual orientation?
A person of a certain sexual orientation.
One of those.
Is that all amount to a sexual orientation? I'm just asking.
Many of them are lesbian, gay, bisexual at least, are certain sexual orientations.
But several different, as opposed to a certain.
Right, you could pick one of the stripes on the flag. I think you definitely could. You could have a reasonable inference that a person is associated with a person of lesbian or gay.
The Girl Scouts walk up to the door if they had left a note that you can buy cookies at this location tomorrow. Is that a simple misdemeanor because they left an object there?
Anybody going after the Girl Scouts? But under the words of the statute, I think leaving an object, inanimate or animate, that's all objects, without the express permission of the property owner is prohibited. And getting to
Constitutional under the Watchtower case?
object part of it is, it didn't come across.
What saves it from, you can walk up to the door and knock, but, and that's protected, but leaving a flyer for a political campaign or Girl Scout cookie crosses the line if you tape it to the door?
People think that it's okay does not make a constitutional right. Thinking that you can do it doesn't make it protected by the U.S. Constitution or the First Amendment. And, you know, the number of, I gave the example of speeding on the freeway. You know, the number of infractions that you can find there doesn't make it illegal to prohibit speeding because everybody's doing it. So I think that that goes to overbreadth.
People are not prosecuted, but once there's a controversial content or words used on the note, then that's prosecuted. Doesn't that trigger some First Amendment concerns?
5 people called law enforcement immediately after finding these notes on their doors, these threatening, intimidating notes. They were selected because they were threatening, because they were intimidating, and the prosecutions did proceed, and he was convicted because of the content of the note. But it's not the content that's prohibited by the statute. The statute is content neutral, has no viewpoint discrimination. The First Amendment says Congress shall make no law. We're looking at what the law prohibits. And what the note told us here is, I did this because of your pride flags. I did this because of your association with a person of a certain sexual orientation. And so the
Political affiliation as well. I mean, I think at this point, the flag is associated very heavily with like a political movement. You know, it's
has become politicized, true, and it could have been that basis as well, and that is part of the hate crime statute, the political affiliation. For the overbreadth part of it, I think your question goes to whether it's an overbroad statute, and you have to tie that overbreadth to protected, to First Amendment protected activity. And so if it's encroaching on First Amendment protected activity, then you have a problem. But there's no First Amendment right to come onto somebody's property and stick a sign on their property. So the overbreadth part is also foreclosed by State versus Chase, which said the prior version of this statute, which is materially indistinguishable from this one, was not overbroad, didn't encroach on protected First Amendment activity.
Stealing, or they're taking property out of the house. Okay.
Did the overbreadth challenge and couldn't point to any protected activity that was being encroached upon. And the court said, if the defendant doesn't point to any protected activity that's being
Protect theft under the First Amendment. They're walking away with property they didn't have a right to take. Chase seems distinguishable to me.
But in an overbreadth analysis, the defendant gets to put himself in the shoes of anybody who is coming on the property for First Amendment purposes and gets to assert their First Amendment rights, because we protect First Amendment rights so much.
Mr. Geddes had been standing on the side of a parade on a public street, a pride parade, and he held a sign, burn those gay flags. Would that be protected speech?
Protected, I think. And
To a door that didn't have a no trespassing sign, left a note, that's where he loses his First Amendment protection?
Protection on somebody else's property to bring his message to bring his message on the property. We're not letting him come in the front door because he wants to tell us something. He doesn't get to walk in and say, you know, I have a message for you. I'm going to tell you I got a First Amendment right to do it.
Let me ask a statutory issue. What do you make of the difference in the various hate crimes under the statutes and the different wording between, for example, an assault, which is a hate crime, versus trespass with the intent to commit a hate crime. There's an argument here that those should be given different meaning because of the difference in the language.
Right, and an assault is committed when it's through, when it's finished, right? And the same goes for arson and criminal mischief. You know, the act is done when the damage is done, really. The trespass, you enter, and then you can prohibit it if you show the intent is for the prohibited reason, right? So the trespass is the entry with the intent to do the prohibited act. And so,
Argument. Let me suggest an answer to the argument that I didn't see in your brief, but tell me if you think this makes sense. In the code, the legislature says the arson, which is a hate crime enhancement, assault, which is a hate crime enhancement, criminal mischief, which is a hate crime enhancement, trespass with intent to commit a hate crime enhancement. It may be because we don't have a general attempt law in Iowa that what they're trying to get at is trespass with intent to commit either just with committing the trespass in itself with intent with the necessary hate intent, or trespass with intent to commit one of these other hate crimes where you stop short. You didn't actually go through with the arson. You didn't actually go through with the assault, which if you think about the context of some hate crimes, that's not unrealistic. That sometimes is what happens. People start off on the road to committing the hate crime. They trespass onto the property, but then they don't go fully through with the intended action. Does that make any sense?
and it was what I was trying to answer Justice May's question and say that I think they tried to. You didn't cut it off. I wasn't being clear enough, I guess. Or I wasn't getting there. But
Is the state's position that the statutes at issue are ambiguous?
I think you could. I said in my brief that you can read it two ways, and then you can get to canons, and you can say, it sounds like it requires a second hate crime, and does it require a second hate crime? Is it entering with the intent to put the object and then remaining on wrongfully intending to put the object because of the prohibited reasons? That it requires two separate acts and two separate intents, I think is not as good a reading as the district court had, and that takes me to where I wanted to start, was error preservation. The statutory interpretation parts are not preserved. The law of the case should be what the district court had in the findings of fact and conclusions of law as far as the elements go, and that's how the sufficiency part should proceed. And with that, we tried to follow those tracks that the district court did and said, trespass is entering without permission with the intent to place an object because of the disassociation with a person of protected status.
Ambiguous, does that bring the rule of lenity into play here?
The rule of lenity only comes into play if the defendant's reading is the right one beyond a reasonable doubt, and I don't think it's the right one beyond a reasonable doubt. So the rule of lenity doesn't apply, and I think I said that the trespass statute and the hate crime statute aren't content related. The State versus Chase says that this trespass provision was not punishing content, and the Hennings case and the McKnight case say that the hate crime statute aren't running afoul of the First Amendment.
Counterman case changes the analysis here a little bit. What is your response to that?
First, I would say that we don't have to get to the true threats unless you find it overbreadth. If you find it overbroad and you need the harassment option to wrap in the with the intent to commit a public offense option, and then you have to look at the harassment. Is it a true threat? But counterman requires a specific intent to a recklessness standard of the guilty mind standard. So I think the district court did that, but if you're not sure, you can remand and have for further proceedings to look at the counterman decision. But I think his response to the police charging with the fifth count, I think, is evidence that he knew that it was threatening, that he knew that this was coming because it was an intimidating and a threatening note.
If I understand, other than the harassment piece, which you indicate maybe counterman does have some relevance there, it's otherwise not relevant unless we have to get to that part of it.
That, if you find it overbroad, which please don't.
Bench?
Thank you.
I want to start with where Justice McDermott began, and that's with the association question. I do think you need more than just a flag or a doormat or a sticker in a window, which all of these things were, in order to establish an association with a person of a certain sexual orientation. Flags don't necessarily indicate that you are aligned with a certain person. There could be various reasons why people have flags. For example, I might have an Iowa State flag flying at my home. I didn't go to Iowa State. I went to the University of Houston. I'm not aligned with Iowa State, but it's flying in front of my home. I might not know anyone who went to Iowa State, and I'm just living in Iowa and wanting to join the fray. And so I think you need more than a flag or any of those things to establish an association.
And a gay flag are not very close, are they, other than they're both flags?
Using flags as an example.
Girl Scout analogy that everybody's using, I'm a little bit offended. I'm a former Girl Scout, but anyway.
So let me ask you this about that issue. Does it matter whether the flag has an objective meaning, associating folks with other folks of certain sexual orientations, or does this because of language in the statute, does that mean that we ought to be thinking about how the defendant thought about it? In other words, if the defendant associated the flag with a particular sexual orientation or whatever it might be.
Language of the statute says because, it does say because of, but then it goes on and says a person of a certain sexual orientation. So I think the person actually are associated with someone. I think the person either needs to be of a certain sexual orientation or has to be associated with someone. And then to just...
Flag argument. And I guess I don't want to dwell on it at any great length, but it seems to me that the whole purpose of a flag is to publicly express affiliation, association with the message communicated by the flag, right? A ship flies an American flag for the express purpose of declaring that it is an American ship associated with the United States of America. I'm a Hawkeye. I have an Iowa flag because I'm associated with the University of Iowa and other people associated with it. It seems to me that it's really defies common sense to say people fly flags to express disassociation or something other than relationship with the idea or the people associated with that flag.
It's disassociating. I'm saying it might not have any association at all. My daughter loves rainbows, so I might be flying a rainbow flag for her, but I might not be affiliated with that movement. So it could go either way.
Compromise and say it's a question for the fact finder, and here the fact finder found against your client.
Well, I think that's why it comes down to statutory interpretation. I think we do have to analyze what the legislature meant, and if they meant specifically have to be associated with the person or you are that person, then I think that it becomes a sufficiency issue, which is what it is here and how it's presented. I will say, I'll come back to that. I do want to go to what Justice Waterman talked about earlier, which is unconstitutionally vague and overbroad. I do think that because so many people approach doors, as we've talked about, Girl Scouts, and I keep bringing back that pizza parlor reference, that means because it's generally accepted, someone is not put on notice, an ordinary person is not put on notice that that is a crime, because we do it all the time in our community. And so that's why Mr. Geddes didn't think it was a crime to approach a door and place a note. And then because, as I forgot which justice referenced this, but because the Girl Scout is not prosecuted, but Mr. Geddes was, that's arbitrary enforcement. Those two things together are vague and unconstitutional. And then you put on top of it that Mr. Geddes was punished for his words, and then that makes it overbroad because he did have the First Amendment protection to say what he needed to say, as long as it didn't fall within those restrictions.
To say, put it in your own yard. I mean, really? He needed to say it?
Those were my words, but there's nothing that prohibits him from doing what he did, which is putting a note on a door. It's protected.
Selective enforcement make the language vague.
I just think that it's a part of the vagueness analysis. So the first part is that anyone can approach a door. You don't think that you would get in trouble for that. And the second is the arbitrary enforcement, where the police are selecting who to, I see I'm out of time.
Doctrine about that the law is insufficiently defined such that the law enforcement officer is actually defining the crime. If we know the crime and it's just an issue of when it's enforced or not, that's a selective prosecution issue, not a vagueness issue, it doesn't seem like.
Well, I respectfully disagree. I do think arbitrary enforcement by the police can come in the form that I'm putting forth as well, which is selecting who to prosecute.
Marijuana possession statute, and a prosecutor just said, I'm only going to enforce this over X quantity and not against anybody who's under my particular threshold. Does that mean the marijuana possession statute is vague?
Two-step analysis. So the first is that leaving an inanimate object is vague. And then you couple that, obviously, with the arbitrary enforcement. I see I'm out of time. I've gone over my time. If you would please remand this case, thank you so much.
The case of State versus Geddes is hereby submitted, and we are adjourned for the afternoon.